First of all, welcome everybody. It's great to see such a tremendous turn-up for this significant occasion, the Walter Lippmann Oration. Before I start, my name is Eddie Micallef, as Marion pointed out, and I'm the chairperson of the Ethnic Communities Council. We are honoured to and delighted this evening to have Professor Gillian Triggs, the President of the Australian Human Rights Commission, to give the oration tonight. And she joins a long list, I think it's 7 or 8 of these events we've had. And I think, look, it is just wonderful that we have a significant oration and in memory of a wonderful person who was one of the pioneers of multiculturalism in this state and this country. We also have Elizabeth Compton, Chief Executive Officer of VITS, the Victorian Interpreting Translating Service, and VITS are one of the main sponsors for this evening's event. Without that sponsorship, we would have difficulty in running it, but that is pretty important. We also are expecting John Pandazopoulos, the former Minister for Multicultural Affairs, Professor Andrew Marcus. He's becoming a significant attender at this event, Andrew, and who's co-author of the book about Walter Lippmann, and we'll say some more about this later. Srinivasan from the Multicultural Commission, representing Helen Kapelis. Thank you for your attendance, Srini. We also have Joe Caputo, the chair of FECA. That's our federal body. The ECCV is the state body and FECA is our federal body. And we have people like Jill Morgan, of course, who sneaks in, and other guests. I think also I must acknowledge the Deputy Chair, Marion, and the board of the ECCV, board members. There's a significant number here today, and staff who helped design it, process it, and put it all together under the guidance of Irene, our Executive Officer. The ECCV is called the Voice of Multiculturalism, and I think that's important for over our 40, I think it's our 43rd year. And remember, we were 10 years or so ahead of the VMC, the Victorian Multicultural Commission, so we've been around a long time. We celebrated our 40th anniversary some years ago at St Kilda Town Hall to a packed attendance, so we're very proud of that, and I think history shows that Australia, in its presentation of multiculturalism, is a world leader in that event. These things don't just happen, they don't just fall out of the sky, it takes a lot of work. We're also very appreciative of the support of the Lippmann family, to have given tremendous support to this event every year. So we certainly acknowledge, and we think that's just wonderful, and we hope that continues to happen. As we listen to Professor Triggs, we will talk about Walter Lippmann, who was one of the founders and initial chairs of the ECCV, and people like Victor Borg worked with him all those years ago. Victor is a former chair of the Ethnic Communities Council. I was also privileged to know Walter personally during the years when the first year of the Kane Labor government back in 1982, I was invited to participate in a working party that established the Victorian Ethnic, the VEC, the Victorian Ethnic Communities Council of Victoria, which became the VMC. Work with people like Caroline Hogg and Des Storr, a whole range of other people in those days. So, and I got to know Victor during that process. It was only not a long-term association, but it was an important association. Before we hear Professor Triggs, I would like to welcome our sponsor, Elizabeth Compton, to talk to us about VITS and acknowledge her organisation as the key sponsor for this evening's event. Elizabeth?
Well, good evening, everyone. Thank you so much for having me tonight. It's a real privilege to be here, and I want to thank the Ethnic Communities Council of Victoria for this opportunity to support this event with Professor Triggs and speak with you briefly tonight. So tonight's focus is obviously human rights. The Victorian Government recognised its obligations to ensure an individual's access to government services, even if you didn't speak English or had low provision of English, back in 1979, and that's in fact the year we were established by the government of the day. So VITS was founded on the basis of access and equity for all, which are two of the fundamental building blocks of an individual's human rights. So I'm not sure if anyone's had the inclination to trawl through the recent census data from last year, but if you have, you would have seen that the proportion of Australians who are actually now born overseas has risen to 28%. So it's at its highest level in over 120 years. So that's 6.7 million of us. And obviously we're a country of migrants, but we've now hit a peak. And like I said, we haven't seen these kind of levels since the mid to late 1800s during the gold rush. So I think that tells us that the services that we deliver, that of ECCV, the Human Rights Commission, they're as relevant and important as ever. Now, I think we all know the ABS, or the Australian Bureau of Statistics, had a few hitches last year when they were pulling together that data. So we just thought we'd try something to validate that. So we just wanted to see, put your hand up if you or your parents were born overseas. Wow, okay, good. ABS got that right. And put your hand up if you speak a language other than English. Okay. Good, that's still pretty impressive. That's very good to see. So the ABS was right. So at VITS we speak over 160 languages. I think most people would be hard-pressed to even think about 50 languages, let alone 160. But I think that's an indication of the wonderful, vibrant diversity of our community. Languages such as Rohingya and Karen from Myanmar, or Oromo spoken in Ethiopia and Eritrea, or Bari from South Sudan. These are the languages that you may have not heard of, but VITS is providing interpreters and translators in these languages and 156 other languages and growing every day. So I guess we think of ourselves as connectors. We connect people when it matters most. We connect face-to-face, via telephone interpreting, or using our latest app-based on-demand video interpreting. We interpret for people if they're presenting at hospital and sometimes receiving life-changing diagnosis, attending a police station or a court hearing, or even a mother taking her newborn baby to a maternal child and health checkup, or a parent attending a parent-teacher interview. These are the connections that we help. We also bring people in business together. So a non-English speaker can open a bank account, inquire about their electricity bill, or even take out insurance. So whether it's the most, I guess, life-changing circumstances or simply the ability to inquire about a bill, language is the link to all of this. So we see VITS services as a small yet vital link in enabling people to fulfil their human rights via access, equity, and control of their lives so they can participate in society. So last year we helped over 250,000 people via our services, and we've been operating now for almost 40 years, and we continue to participate in the sector, sponsoring events like tonight, and also partaking or sponsoring research. So we're currently working with Monash Uni, looking at the role of an interpreter in mental health settings, and we've also sponsored research into the role of an interpreter in family violence situations as well. So we look forward to sharing the outcome of that research shortly. So Professor Triggs, in a recent speech, I think you recently said human rights are intended to protect the most vulnerable, to redress imbalances of power in the community, and to advance fairness and equality for us all. So now, no doubt, as I look around the room, there are many people here tonight who, whether that's in their formal work or via volunteering, in a volunteering capacity, contribute towards that end. And in some way, VITS also, in a small way, contributes to that outcome, and that's something we're very proud of. So I think you can see why, with that short overview, VITS is so proud to be a part of tonight, to sponsor the Walter Lippmann Memorial Oration, and we welcome Professor Triggs. So thank you very much.
Well, Elizabeth, thank you, and thanks for that explanation about VITS and its role. And I'd note in the state budget that $24 million over 4 years would be a welcome to improve the standard and ability of people to access interpreter services. So I think that's pretty important for the reasons that you pointed out. And also for the sponsorship. Again, once again, thank you very much. Before look, I'm a bit remiss, I did not acknowledge the traditional owners, and I'll smack myself for that, and acknowledge their elders past and present, and we certainly appreciate the fact that we're welcome in this country. Now we get on to the main act for the night, and we have Professor Gillian Triggs, and it gives me great pleasure to introduce her, but I'll say a few words. I'll try and truncate it a bit, Professor, because it's so long. Emeritus Professor is the President of the Australian Human Rights Commission. I think that's the key point. That's why you're here tonight. You were previously Dean of Faculty of Law and Challis Professor of International Law at the University of Sydney from 2007 to 12, and Director of the British Institute of International and Comparative Law from 2005-7. You're a former barrister and a former Governor of the College of Law. You combine academic and international commercial legal practice, advised governments. I think we note that. That's quite obvious. It focuses on the Commission on the implementation of human law in relation to human rights treaties, which Australia is a party, and sometimes we forget that we are signatories to some international treaties which we are technically bound by law, which sometimes some of us seem to think we're above it. You're the author of many books and papers on international law, including International Law, Contemporary Principles and Practices. So can you please put your hands together, and Professor Triggs has agreed to take questions at the end of her oration. So welcome, Professor.
Well, good evening, everyone. Yes, I do purport to advise governments, but as you can see, they don't take very much notice of me, unfortunately. Thank you very much. Well, I too, of course, in this iconic Melbourne Town Hall, also acknowledge the traditional owners of the land, the Wiradjuri peoples, and respect their elders, especially if there are any here tonight. Well, I was, of course, introduced as an emeritus professor, and that is technically true. And an erstwhile friend of mine said to me not very long ago that the word emeritus is Latin for has-been. And that brought me back to earth a little, but I'm not quite a has-been because I've got 3 more weeks before I step down. And I can't think of a better way to do it than in these last speeches that I'll be giving, particularly this week. And I can't think of a better place to come to than the Ethnic Communities Council of Victoria. I do, and we do at the Commission, owe you so much for reasons that will be clear as we go through the evening, but I'm sure you all know what extraordinary support you've provided for the law and for the principles that underpin our multiculturalism. So I couldn't be happier to have this opportunity to speak to you this evening, but also, of course, I'm very honoured to deliver the Walter Lippmann Memorial Oration. and to follow my colleague, Dr. Tim Sook-Parmesan, who gave the oration last year and who gave me a few tips and told me just how wonderful you'd been in working with him when he sought your advice and assistance in relation particularly to amendments proposed to the Racial Discrimination Act. Well, just a few words about Walter Lippmann, because we are here to remember him and the work that he and indeed his wife did as well. He was the founder, as has been said, of the Ethnic Communities Council, but he was really an architect of Australia's multicultural policy. In 1974, he chaired a committee on community relations that tried to articulate for the first time in Australia the philosophical basis for multiculturalism. And the report by that committee had a vision that is still vital today. It called for greater cultural sensitivity to cultural diversity and noted that a harmonious understanding and national cohesion among Australian citizens can be achieved only through accepting newcomers in a spirit of understanding and recognition of their right to equality and treatment of opportunity. And I notice that these are the very phrases, of course, that are used here on your banners. I couldn't have said it better myself. Well, the leadership demonstrated by Walter Lippmann laid the groundwork for our contemporary approach to multiculturalism, a social policy that underpins Australian law and policy. Multiculturalism is today endorsed overwhelmingly by most Australians. 85% say that multiculturalism works. Indeed, our political leaders insist that we're the most successful multicultural society in the world. Well, whatever you think of the truth of that rather grand statement, our globalised world is one of growing tensions and unpredictability among powerful nations. We have threats to what I thought were clearly agreed ideas of free trade. We have growing economic volatility. We have a rise of populist nationalism and anti-immigration sentiment reflected in the electoral success of the far-right political parties in parts of Europe. The 35% vote for Le Pen in France, while reassuring that Le Pen did not win that presidential election, it's still obviously a matter of concern that such a high number of French citizens were prepared to vote for those policies that Marine Le Pen espouses. But we also find right-wing political parties emerging in North America, as we know clearly, and more recently in Australia. And each of these elements contributes to a toxic mix fuelled by the media and by some of our political leaders. Over my professional life, now of nearly 50 years, since I did my law degree here up the road at the University of Melbourne, I can think of no more important time than now to speak up for the ideas that inform Australia's commitment to multiculturalism, to non-discrimination on the basis of race, to equality before the law, and to cultural, racial and religious inclusion. We need to push back against political spin, alternative truths, and the cynical view that the truth is anything you can get away with. We need to be vigilant in rejecting finely tuned and artfully camouflaged whistling to extreme right-wing groups. Walter Lippmann was prescient in 1976 when he observed that at times of social and economic uncertainty, insecurity creates fear in the hearts of many men. Fear makes people susceptible to prejudice, and prejudice distorts our values. He well understood that it's fear that fertilises the ground for racism that now threatens Australia's agreed values of a liberal democracy under the law, founded in the principles of equality, respect and dignity for all cultures. Well, it was no accident, I suggest, that the year following the Lippmann report, the federal government enacted the Racial Discrimination Act in 1975, giving effect legislatively to the Convention on the Elimination of Racial Discrimination, negotiated 10 years earlier in 1965. And you'll be familiar with this language of the Convention. It prohibits discrimination, exclusion or preference based on race, colour, descent, nationality and ethnic origin if this nullifies the enjoyment on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural or any other field of public life. Now, these were ideas that emerged out of the Second World War. Many of you here tonight will be well aware of that. They were grand. It was a grand vision and a grand articulation of one of the most fundamental principles of human rights, adopted ultimately 10 years later in the Racial Discrimination Act of 1975. That Act provides the architectural or skeletal frame on which the principles of multiculturalism have evolved, and indeed I'd suggest depend. Before 1975, no law in Australia prohibited racial discrimination, and no remedy could be provided by the courts for an injury suffered as a consequence of it. Well, 2015 was the 40th anniversary of the Racial Discrimination Act, and this led to some thought and reflection about the Act. And it became apparent to me and to my colleagues at the Commission that the Act is the closest Australia has to a bill or to a Charter of Rights. And perhaps for that reason, it's attracted the most political and media commentary, certainly during my time as President. Well, this evening, I'd like to focus on the role that the rule of law and substantive laws themselves have played or failed to play in protecting multiculturalism in the specific context of issues that I know you'll be familiar with. Section 18C of the Racial Discrimination Act and the balance with the right to freedom of expression, the disproportionate impact of Australia's migration and asylum seeker and refugee policies on vulnerable racial, religious and ethnic groups in Australia, and finally the Prime Minister's proposal that Australian citizenship should be confined to those who can demonstrate that they accept Australian values. Well, just a few preliminary comments before I move on to 18C, because over my 5 years as President, I've had a commercial legal background and an academic background. I've come to understand more deeply the power and the frailties of the law. It's become axiomatic that it's one thing for Parliament to pass laws, but it's quite another to give those laws practical effect. And I've learned that legislation can be effective only with genuine community and cultural support, the kind of support that you provide. It's true, the law cannot prevent racist acts or words, but the law does set the benchmarks against which social behaviour can be measured. The law can promote cultural norms that racist behaviour is unacceptable within our community. But in trying to understand the role that the law can play in multicultural policies, it needs to be understood that Australia is exceptional and I believe profoundly isolated from other countries in its failure to provide the legal tools to protect human rights. And it's astonishing that what I'm about to say is not generally understood within the Australian community. It's notable that Australia is the only common law country in the world that does not have a bill or a Charter of Rights. And as was pointed out quite correctly, Australia has been a major international supporter of human rights since the days, and some of you in this room will remember, of Dr. Evatt, that rather feisty, argumentative but brilliant lawyer who went to the United Nations to Dumbarton Oaks in 1944 and helped to negotiate the language of the United Nations Charter. He was then invited back 3 years later by Eleanor Roosevelt to join her with a few others to help to draft the language of the Universal Declaration of Human Rights that was passed under his presidency of the General Assembly in 1948 without a single negative vote. And I'm reliably told that it was because of Doc Evatt that that vote was achieved. No negative vote on the fundamental principles that were to underpin all that we wanted to articulate in terms of human rights and build on that from the years after the Second World War. He was a remarkable man, and I hope that we do come to honour him rather more than we have done. But my point is that from those early days, Australia was strongly engaged with negotiating the terms of the international treaty system. And there are many of them, and you'll be familiar with them. The International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Rights, the Convention on the Rights of the Child, the Refugees Convention, of course, the Convention Against Torture, the Convention on the Elimination of Racial Discrimination that we've just been talking about, and the Convention on the Elimination of Discrimination Against Women, and then the most recent of them, the Convention on Disabilities and to end discrimination on that ground. Now, that is the suite of conventions that Australia has been a major party in negotiating from Doc Evatt's day through the period of the 70s, the 80s, the Whitlam government, obviously, Gareth Evans supporting these treaties over the years, right up until the drafting of the Rome Statute for the International Criminal Court in the mid-90s. We were active engaged parties in the international human rights environment. But then we found in the 90s, and I'll come back to this point in a moment, we saw a decline in willingness to be part of that international environment on human rights. But the reality has been that despite negotiating and ratifying these treaties, and it's been pointed out they are binding on Australia, they have not in the main been introduced into Australian law. And that means that if you can think about it as two bubbles, we've got a bubble of international legal obligations that Australia played a very strong role in negotiating. But as they've not been introduced by legislation by Parliament into our domestic law, they're not part of our domestic legal system. And it's perhaps people don't really understand that the Convention on the Rights of the Child, which has been, I think, the only competitor in terms of number of ratifications is the Genocide Convention, is one of the most ratified conventions in the world. We haven't given effect to that in Australian law directly. The Refugee Convention was given effect in some provisions of the Migration Act, but they've been stripped away in the last 2 or 3 years by the government with barely a murmur by the Australian public. The International Covenant on Civil and Political Rights has not been implemented into Australian law, nor has the Convention on Economic, Social and Cultural Rights. And I could go on. There are 3 exceptions. One I've already mentioned, the Racial Discrimination Act, the other being the Sex Discrimination Act, and the last being the Disability Discrimination Act, which in fact was Australia leading the way. We had domestic legislation before we had a treaty. So it's been a very, very mixed and unusual phenomenon that we haven't got a Charter of Rights. We haven't implemented most of the international treaties in domestic law, so the courts can't apply them. And we've also got a failure in our Constitution to protect many of the basic rights that we think we've got. We have a right to vote, we've got a right to a fair trial on federal charges, we've got a right to be compensated if our property is taken, and we've got a right to freedom of religious expression, one of the main fundamental human rights provisions that was actually included in our Constitution. But there's no right in our Constitution to freedom of speech, and it took the High Court of Australia to imply a right of political communication, but that's all. The common law has not proved to be an effective protection for fundamental rights because of the supremacy of Parliament. Now you would say that's fine, that's what we've got a Parliament for, but the trouble is that majority governments, often backed by opposition parliamentarians, pass laws which are explicitly or impliedly in breach of our fundamental freedoms. And when that law is clear and unambiguous, the courts cannot go to the common law. So that even principles as old as the Magna Carta, particularly the right not to be detained arbitrarily, even those rights are not directly enforceable rights under Australian law, where Parliament is clear, Parliament has spoken, there's supremacy. So these are serious problems in my view, and they've led to legislation, particularly over the last 5-6 years, that is seriously in breach of the fundamental rights that we would have taken for granted on the basis of the Magna Carta alone, let alone millennia of laws since that time. Well, let me move to the first of the areas that I wanted to cover, and that is the right to freedom of speech and the vulnerability of ethnic minorities to verbal abuse. The Australian Human Rights Commission has a specific statutory obligation to investigate and to conciliate, if possible, complaints under the Racial Discrimination Act. And the most controversial provision, and I'm sure you all know, is Section 18C, that prohibits acts that offend, insult, humiliate and intimidate a person because of their race, national or ethnic origin in a public place. It's quite simple. It's got to be because of race, in a public place, and it's got to offend, insult, humiliate and intimidate. This section is vital, I believe, to the protection of ethnic minorities in the community against racial abuse and hate speech. Well, you'll all know that efforts have been made by both the Abbott and Turnbull governments to amend 18C by deleting the words offending and insulting and adding new words. They've objected to 18C on the ground that it has a chilling effect on freedom of speech, this despite the consistent jurisprudence of the federal and circuit courts that the prohibition does not apply to mere insults, and it's never applied to minor matters, but always required profound and deeply injuring insults and abuse. The position of the Commission has been that 18C should not be amended, as it's been applied for the last 20 years since it was introduced in a fair and balanced way by the courts. it's a proportionate measure to achieve a legitimate aim and sends the vital message to the community that racially abusive language will not be tolerated. The defeat of the 2 bills to amend 18C owes much to the multicultural community. All of Australia's ethnic and religious communities, Chinese, Vietnamese, Muslims, Jews, Christians, Buddhists, Italians, Greeks, and of course I'm leaving many out, worked collaboratively, united by the sure knowledge that this provision is a foundation stone for our multiculturalism. The national debate by the government and media commentators over the last 4 years has been essentially ideological. It's much ado about nothing when you realise that only a handful of 18C cases has ever been successful before the courts. As John Alexander pointed out, has one of the electorates in North Sydney, that 18C is not in the top 100 issues for his electorate. Most 18C cases fail, partly because they don't meet the high threshold imposed by the courts, and partly because the free speech protection provided by Section 18D operates. For as you will or may know, the act or speech, if prohibited by Section 18C, will nonetheless be protected by Section 18D if it is in good faith or in the public interest or a work of artistic or scientific purpose. Indeed, it might be noted that Section 18D is perhaps the strongest legislative protection for free speech in Australia, given that there's no other constitutional or legislative protection beyond the implied right to freedom of political communication. One instance in which sections of 18C and D have been used successfully is to challenge Holocaust deniers brought by the Jewish community. The Bolt case has also been an exceptional one, for despite the high threshold for such a civil action based on 18C, the Federal Court found that the right to freedom of speech does not apply where the journalist gets his facts wrong and acted in bad faith. Well, last year, the Parliamentary Joint Committee on Human Rights, the so-called Scrutiny Committee, little known or understood in Australia, sadly, was asked by the government to report on reform proposals to 18C. And in its report a few weeks ago, the committee proved unable to make any recommendation at all. Instead, it listed 6 possible options for reform without suggesting any way forward. The Commission did make some recommendations about the complaints processes of the Commission, most of which have been proposed by the Commission itself. And you'll know that we've been much and roundly criticised for handling the QUT case and the leak case. We have been cleared of any failures in relation to those cases, but nonetheless, the fact remains that we now need wider powers to refuse to accept vexatious or frivolous complaints. And as President responsible for these, I'm very happy by those legislative amendments. But so we return to the status quo. That is, the right to freedom of speech continues, in our view, to be sensibly balanced by the prohibition on public abuse on racial grounds. But it should be acknowledged that it's not easy to achieve the balance. As the High Court of Australia discovered in the Monis case of the Muslim cleric who was ultimately responsible for the subsequent Lint Cafe tragedy in Martin Place in Sydney. You might remember that Monis was charged with a criminal offence, among many others, of using the Commonwealth Postal Service to send abusive letters to the parents of Australians killed in Afghanistan. Now, this is a strange provision. It's a little bit like prosecuting Al Capone for tax offences. But what Monis had done was to write these very offensive letters, to use the language of the High Court judges themselves, to the parents. A shocking thing to do, I think we'd all agree. But he'd used the Postal Service to send the letters, and that was contrary to a provision in the Postal Act that prohibited the use of the service for offensive language. So it was a little roundabout, but we get back to basically the language of 18C. He was prosecuted and he was convicted, and he appealed ultimately to the High Court of Australia. And if it can happen, it will happen. Only 6 judges sat on that case. And the 6 judges split 3-3 on the issue of whether the provision in the Commonwealth Postal Act was a breach of freedom of speech. Was it a breach of your right to political communication, to use the language of the High Court? Was it a breach of the right to political communication to write abusive letters to the families of where their sons had been killed in Afghanistan. 3 of the judges said, well, the right to freedom of speech and freedom of political communication is important. What Monis was doing was saying the war in Afghanistan and Australia's engagement in it was contrary to international law, and he was making a political point. So he's got a right to make that point and a right to send a letter through the mail to that effect. So that was 3 of the judges, all of them the men. 3 of the judges, all of them the women, said, no, there's a limit to freedom of speech. There are limits. You can abuse the right to political communication and to use the postal services to send letters that were so abusive, that were so demeaning, so hurtful to these families, was a violation of the right to freedom of speech. Now, because of the way the law works, because the judges at the High Court level split evenly, the lower conviction from the lower court remained on foot. So Monis was convicted of that offence. Now, we all know what happened, of course, much later, the tragedy. But that's not my point tonight. My point is that to determine where the line lies between the right to complain about the war in Afghanistan through the postal services and the right and the abuse of the right to freedom of speech in this particular case is very, very hard to draw. And some of the best legal minds in Australia were not able to be clear as to where that went. Now, had there been 7 judges when that case was heard, well, we'd have had possibly a different result, or maybe it would have been confirmed, I don't know. But the point I'm making is nobody has the truth in terms of where that dividing line is. And each generation will have a different view of where that line is. But perhaps my point is that we have to recognise that there's a right of political communication to freedom of expression, but there are limits to that right, and that is possible on occasion to breach it. And I'd suggest, and ultimately I think the Australian public generally agrees, that 18C does defend the Australian public against abuse on racial grounds in the public arena. You can say what you like privately, but in the public arena you cannot use language which is abusive. I think it strikes a fair balance. People can have a different view about that, but I don't believe, in fact, that this has really been the key issue for the government. I think it's been a highly ideological issue. Well, we know that all of the reform attempts failed, and the most recent attempt failed, and I'm rather pleased by some news that I just received today, because you have to remain alert and alarmed about attempts to reform this law. The embers of that reform fire are still smouldering, because last night the Senate Legal and Constitutional Affairs Committee tabled its report on a third bill to reform Section 18C by removing the words offend and insult. The majority report was half a page, and it recommended the bill be passed, but there were minority objections by the Labor Party and the Greens, and for these reasons it's highly unlikely to pass in the Senate. But the ideological objections to 18C remain alive. Well, the next issue I want to briefly discuss is the disproportionate effect of migration and national security laws on racial and ethnic minorities, but especially those of the Muslim faith. Over my 5 years as President, I've learned a lot, but one thing I've learned in particular is the damage done to social cohesion by ill-informed stereotypes. To generalise about the human rights breaches that concern most Australians most of the time, they're not asylum seekers, or Indigenous incarceration rates, or even domestic violence. Most Australians complain to the Human Rights Commission, and we get 20,000 inquiries and formal complaints a year. Most complain about being treated in stereotypical ways. They're not treated as individuals, but rather as representatives of a group, whether as an older person. I'm shocked by the discrimination against people over 55, especially as I am rather more than that. But preconceived ideas about gender, sexual orientation, ethnicity, religious beliefs, and of course Indigenous Australians who suffer extraordinarily disproportionate rates of incarceration, domestic violence and ill health. Stereotypical thinking has been especially damaging for Muslims in Australia, and it reflects a combination of factors over the last 16 years, arguably since the momentous year in 2001. And many of you will know where I'm going. In 2001, that was the year that the Norwegian freighter the Tampa sailed into Melbourne with 433 asylum seekers, mainly Shia Muslims and Hazaras from Afghanistan, who'd been rescued on the high seas by a kindly and rather courageous Norwegian captain. The Tampa incident was followed in October in that year by allegations from the Howard government that asylum seekers arriving in Australian waters without a visa were throwing their children overboard to ensure that they were rescued and taken to Australia. Allegations that were, months later, proven to be false by a subsequent Senate inquiry, but the damage was done and arguably an election was won. Some weeks later, on the 9th of September that year, the attacks were made on the Twin Towers and the Pentagon in the United States, with that tragic loss of life sparking the continuing conflicts in Afghanistan, Iraq and Syria, with even greater monumental loss of civilian life. And the following year, in 2002, we saw the Bali bombings that exacerbated anti-Muslim feelings, along with some criminal trials held in Sydney that year. Well, a common feature of all of these events and their aftermath has been the links made between all those of the Muslim faith and the people smuggling trade, global security, terrorism, and religious fundamentalism. Links that have been promoted explicitly, sometimes more subtly, by political and community leaders. The recent example of the growing tolerance for demonising Muslims generally has been the controversy over a Facebook comment on Anzac Day by Abdel Magib, a hijab-wearing Muslim woman. She drew attention to the plight of detainees on Manus Island and Nauru, and of the refugees from Syria and Palestine. Despite a speedy apology from her for what she conceded was a disrespectful comment on this important day of remembrance, this relatively minor incident has been used to demand the removal of Abdel Magid from the Council of the Australian-Arab Relations, to constrain her right to freedom of speech, and to demand that as an Australian resident since she was a child, she should return to Sudan, her country of origin. It's very encouraging that our Minister for Foreign Affairs has not succumbed to this kind of abuse. This single incident, however, clearly touched some raw nerves. Indeed, the headscarf has become a lightning rod for attacking Muslim women. The incident also prompted further ritual attacks on the independence of the ABC, and the popular nationalist language has now started to emerge that we should put Australia first. How can and should Australians respond to such a damaging mix of racism, misogyny, national populism, and legal isolation from our international legal obligations? One response is to present the facts and evidence, to inform public debate with balanced scholarship, and to ensure that we have the laws in place to protect fundamental freedoms. Some facts, of course, are that there are 460,000 Muslims living in Australia, being 2.2% of the population, most living in Sydney and Melbourne, some throughout Australia. Muslims have visited Australia and traded with Aboriginal Australians since the 18th century and came as migrants in the mid to late 19th century. But despite that long history of Muslim engagement with Australia, there is consistent evidence that Muslims are subject to higher rates of racism than pertains for all other races and religious groups within the Australian community. Of course, racism often overlaps with religious and cultural hostility, and it can be very hard to separate them. But the research is clear. The Muslim community is disproportionately subject to hate speech and discrimination in employment and the delivery of goods and services. A study by the University of Western Sydney found racial prejudice against Muslims to be 3 times that of all other Australians. And the Scanlon Foundation found 2 years ago high rates of reported discrimination for faith groups generally, but that there were significantly more negative attitudes towards Muslims than Christians, Buddhists or Jews. Strong negative attitudes exist in respect of all immigrants from the Middle East compared with all other migrant groups. Well, the Australian Human Rights Commission does, if I may say so, have a special insight into the level of racial discrimination, again through our complaints processes. Last year, of the 19,000 inquiries and formal complaints for conciliation that we received, 21% arose under the Racial Discrimination Act, being about 450. Overwhelmingly, and this is very important, I think, the complaints were not about racial abuse on public transport or in the streets or in the factories. They were about racial discrimination in terms of access to employment and fair access to services. That is what worries and concerns most Australians. If we don't have work, if we don't have fair access to work, it's very hard for any one of us to integrate and to be part of a fruitful citizenship in Australia. So although I spend a lot of time on some of the other issues, Indigenous incarceration, the shocking conditions for juvenile Indigenous Australians in the Northern Territory and in other parts of Australia, domestic violence, asylum seeker issues, that's not actually what most Australians are worried about. It's what I've always been concerned about all my life, the importance of work. It defines us as human beings, it enriches us, but if we are denied it on unacceptable grounds of age, disability, race, religion, ethnicity, then that is about as wrong as it can be in any liberal democracy. And I do feel very strongly about it, I'm sure, as you do. But again, going back to the statistics, very few complaints arise in relation to racial hatred laws. Only 3.8% of those complaints, of the total complaints that the Commission hears. So although there is so much ink been wasted on the question of 18C, and I've spent a lot of tonight talking about it, and in fact it's a tiny number of the complaints that we ever receive, which is why I say it's much ado about nothing. It's an ideological issue. It's not really a substantive issue for most Australians. Well, of course, I've spoken generally about discrimination in relation to Muslims. We also find that Muslims are disproportionately subject to racism in Australia through our migration laws and our treatment of asylum seekers and refugees, particularly the Hazara of Afghanistan and the Rohingya of Burma, Myanmar. It's a sad reality that overwhelmingly asylum seekers and refugees detained in our detention centres in Australia and Christmas Island and on Nauru and Manus are Muslims. And that is not often talked about in the media, but that is a reality. It's not, of course, always easy to know what the figures are, but we do know that most asylum seekers and refugees come from countries that are overwhelmingly Muslim, and that they form the largest group in detention or in the community awaiting assessment of their refugee status. The evidence is that while religious persecution is one of the 5 grounds on which a person can seek protection under the Refugee Convention, when Muslims seek protection against religious persecution, they're subject to yet further discrimination in Australia on the basis of their faith. In addition to those kinds of human rights abuses in relation to immigration detention, and I won't go into that further this evening, there are other and more recent problems emerging with our migration laws. And they are, in particular, the so-called Section 501 visa cancellations on character grounds. The Minister has the power to cancel visas at his discretion in a way that's not reviewable by the courts. And this is another issue of deep concern to me at the end of my term, that we have a growing number of laws which give ministers executive powers to make decisions that are neither compellable nor reviewable by the courts. Now, for me as a lawyer, I know those terms are technical terms, but for me as a lawyer, they are fundamentally worrying, because if you can't challenge what a minister is doing, then there's something gone very, very badly wrong with our democratic system. But it's in Canberra, the law passes, it's not reported in the media, it's not understood, it's complex, and it's the sort of thing only a few lawyers talk about. But these are serious diminutions in the quality of our democracy, and they're matters that I think we need to understand rather better. But sadly, the numbers of those subject to 501 visa cancellations are dramatically rising. And at the moment, I'm doing a series of visits to the detention centres in Australia. We've just done the Melbourne detention centres. I spent 3 days just 2 weeks ago at Villawood, and next week I go to Yonge Hill in Western Australia. Can I ask how many people here have ever heard of Yonge Hill? I bet you, do you have any idea how many people are incarcerated there? You know, it's something like 1,000 people incarcerated indefinitely. A couple of hours drive out of Perth. Most of us have never heard of the place. And they're out of sight and out of mind. And lack of transparency is a matter of real concern to us. But the reality then is that most asylum seekers, all of the children are out of detention, except obviously in Nauru, where I have not had the permission of the government to go, so I've never been able to report on Nauru, apart from the chapter of the report we did on the Forgotten Children's report, but we relied there on expert evidence from others and from detainees themselves. But in relation to all of the others, we've been able to report quite frequently. The irony, however, is that most of those, or at least a significant number of those subject to 501 visa cancellations, are New Zealanders. Sadly, they are Pacific Islanders. And it's been very interesting that the fact that it's New Zealanders that are subject to this mandatory detention has actually created a level of media and public interest in the issue. And I get a significant number of phone calls from New Zealand media outlets and human rights groups to say, what on earth is going on in Australia? How are you detaining without trial, without charge, contrary to the fundamental principles of the Magna Carta? How are you retaining these people for years without release? Now, these are very sad cases, they're very difficult cases. Many have committed serious criminal offences, some have committed small offences, but which add up to 12 months, which technically allows or triggers the provision. So it's a continuing issue, but it's one where there's very little public awareness. Well, let me conclude, if I may, with the question of Australian values and the principles that unite us in multiculturalism. The Prime Minister has recently announced that his government plans to put Australian values at the heart of new citizenship requirements. And he says these values are respect, the rule of law, a commitment to freedom, and a commitment to liberal, democratic, representative government. Who could possibly disagree with these values? They're obvious, and they're already founded in our legal system. The cautious sceptic is bound to ask, what motivates this recent effort to rethink citizenship? The proposal might usefully be viewed in the context of restricting the 457 visas to overseas workers, to the visa cancellations on character grounds I've just described, to echoes of Trumpism with putting Australia first, and the Labor Party's advertisement employing Australian workers first, where overwhelmingly those represented were of Anglo-Saxon origin. One element of a strong national identity is a clear articulation of our national values. The United States especially has been successful in articulating its values through the American Constitution and the Bill of Rights. Every American child knows what the First Amendment allows you to do. My colleague, you may know, Professor George Williams, did some research with 2,000 or 3,000 surveys not too long ago, and he asked the question, do we have a constitution in Australia? And something like 70% of people said no. Then the second question he asked is, do we have a Bill of Rights? And something like 80% said yes. The other story I rather like is, not very long ago, a man was arrested in Queensland for allegedly killing his wife. And on being handcuffed by the police officers, he said he wanted to take the Fifth Amendment. I think we know more about the American Constitution than we do about our own. Ask an American child about the Constitution, they will tell you, they will recite it to you, and they know what their rights are. Ask an Australian child, they really barely know that we have a constitution, and we don't include these, what I used to call civics, in our basic education system. That is why, in my view, the Australian government has been able to get away with passing the kinds of laws that raise rule of law issues, and I've mentioned the growth of executive discretion, but other laws that I, of course, haven't had time to talk about tonight that are very worrying are our counter-terrorism laws and other provisions that just sneak in. They're often in omnibus bills, you don't notice them. There's not a proper debate in Parliament, and they simply go through, and they're too complex for most of us to understand, including me. Well, yes, it's perfectly reasonable to articulate our national values, but to recite what we already know and believe in is not good enough. It may be reasonable to require a few years' residency in Australia as a prerequisite for citizenship. It's certainly worth talking about. But the requirement that a citizen should speak a certain level of English, while reasonable on its face, is problematic because it's open to official abuse and, I fear, to a deeply discriminatory impact. The critical need is to move past statements of the obvious to define Australian values with precision. I suggest that one way to strengthen our understanding and commitment to core Australian values is to set them out in a document that provides a benchmark for all that we stand for. Let us agree upon the principles that underpin multiculturalism: respect for all cultures, religions and ethnicity, equality before the law, non-discriminatory treatment, freedom from arbitrary detention, freedom of speech and association. We can recall the words of our national anthem. We should advance Australia fair, with the operative word being fair, or in the vernacular, a fair go. In conclusion, I think it's time that we set out Australian values by drafting a legislative Bill of Rights of freedoms and responsibilities to which we can agree and around which we can unite. We can then join the rest of the world with provisions that speak for our aspirations and commitments for Australian social justice and freedom. Thank you very much.